Good morning to both of you.
Morning.
Morning, Your Honors.
The next case to come before us this morning is Laura Patterson et al. Versus American Family Insurance Company et al. Both sides will have 15 minutes with which to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellee cross appellant, when it's your turn to speak, you must utilize your entire 15 minutes. We don't have additional rebuttal for the cross appellant. If you're the appellant and you wish to reserve time for rebuttal, if you let me know when you get started, that would be helpful for me because I'm keeping the clock today. In this case, I don't believe it's an issue, but if there are any minors or non-party victims of any sort, please do not state their names as this is being recorded and also posted live on our YouTube channel. The court has read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. I believe I'll be going first on behalf of this wage lock plan, and my plan is to reserve 2 minutes for rebuttal time. So,
Thank you.
all right, may it please the court. This court has to start as the trial court had to start with subject matter jurisdiction. The Ohio Supreme Court has made it clear in a number of cases, including the Patton versus Deemer case, that if a state court proceeds in a case where it doesn't have subject matter jurisdiction, then any ruling or judgment that it issues in the case is void ab initio. And because a subject matter jurisdiction challenge goes to the court's ability to entertain and hear the case in the first instance, it's not something that can be waived. The court either has subject matter jurisdiction or it doesn't. Here it's very clear that the case that the trial court was dealing with and that this court is dealing with is an ERISA case. The Pattersons, when they filed their amended complaint in this case, asserted certain claims seeking to stop this wage lock benefit plan, which it acknowledged is an ERISA governed plan, from doing certain things. And it attached copies of the plan documents to the completing that made it clear that it's an ERISA claim. Both parties proceeded in the trial court below with reference to ERISA and briefing regarding ERISA. And then both parties have proceeded in this case with reference to ERISA and citing ERISA cases and noting that ERISA is the governing law for the plan. And when you have an ERISA claim that's talking about an ERISA plan, the Ohio Supreme Court has given Ohio courts very clear guideposts for where it has jurisdiction and where it doesn't have subject matter jurisdiction. And in the Richland Hospital Inc. versus Rayon case, the Ohio Supreme Court recognized that there are two general kinds of claims under ERISA. There's one claim which is seeking denied benefits or benefits under a plan and seeking to enforce contractual rights to benefits under the terms of the plan. That's a claim that ERISA provides an express cause of action for under 29 USC 1132 A1B. And then there are other types of claims that are equitable in nature, and those equitable claims seek to get rulings about how to enjoin certain practices that may violate a plan or to make certain equitable remedies available to enforce terms of the plan. And the Ohio Supreme Court in the Richland Hospital case said, and I'll quote here, any kind of action not included in subsection A1B falls within the exclusive subject matter jurisdiction of the federal courts. And that's drawn expressly from ERISA itself. 1132E jurisdiction says, and I'll quote again here, except for actions under subsection A1B of this section, the district courts of the United States shall have exclusive jurisdiction of civil actions under this title. And the Ohio Supreme Court went a little bit further in the Richland case and gave guidance and said subsection A1B expressly limits actions cognizable in state courts and only provides for enforcement of contractual rights as remedies.
Isn't that what the court found in this case, that the Pattersons were attempting to enforce their rights under the plan, since their position was that there was no subrogation in the plan, it was only in the SDs?
Your Honor, what the trial court held was the trial court held that the Pattersons were both pursuing a claim under A1B and also pursuing a claim under A3, a separate subsection of ERISA, one of those equitable subsections I mentioned. And it got it wrong for two reasons. Number one, if you look at the actual amended complaint that the Pattersons filed, they don't ask for any benefits under the plan. There's no request for any type of benefit of any kind. They're not looking to enforce any term of the plan that gives them any benefit. Instead, what they asked for was an order declaring that the defendant, the wage lock plan, does not have a contractual subrogation or reimbursement interest for any benefits paid on behalf of the plaintiff, Laura Patterson, and barring any exercise of any claim, subrogation, reimbursement interest for benefits paid on the plaintiff, Laura Patterson's behalf. That's not an ask for any benefits. It's asked for an order declaring what the rights of the plan are to subrogation reimbursement and barring it from asserting certain rights that it claims to have under the plan. That's what 502A3 of ERISA, which allows for acts to enjoin practices in violation of the plan, is expressly for. So if you look at the nature of what the plaintiffs have actually pled in their complaint, it's not a claim for benefits. Also, U.S. Supreme Court case law, including in the Verity Court versus Howe case, have made it clear that a legal right to benefits under A1B, a claim for benefits, is a legal claim. A claim under A3 is an equitable claim. And everyone recognizes that if you've got a valid legal remedy, then you can't pursue an equitable remedy. They're exclusive. So federal jurisdiction case law actually says that you can't have a simultaneous claim that can be both an A1B claim and an A3 claim at the same time. So I think if you look at the nature of what the Pattersons have actually alleged, it's clear that they're seeking that equitable remedy, which is the exclusive federal court jurisdiction. Also, the trial court engaged in a little bit of a waiver discussion. And I think it's important to recognize that from a waiver standpoint, as I mentioned, subject matter jurisdiction isn't waivable. It goes to the court's express ability to hear a case. And here, even if waiver were applicable, there's simply no way you can look at the facts of the case and find waiver. This defense of ERISA preemption of claims and subject matter jurisdiction of the court was asserted in a motion to dismiss, the very first pleading the plan filed in the case. The answer included a defense that there was a lacking of subject matter jurisdiction. In summary judgment, the plan contended that it was lacking of jurisdiction. And that fits squarely within Ohio Supreme Court case law that says as long as a defense of subject matter jurisdiction is raised before trial, it's not waived. And all of the cases that are cited to the contrary by plaintiff all concern post-judgment motions and other things that don't match the facts of this case at all. And I think turning to the merits of the actual claim, if the court could reach it, which it couldn't for the reasons I've articulated, I think you can understand why the trial court struggled to have an understanding of these plan documents and how they work together, because that's something that's traditionally exclusively within federal court jurisdiction, as I've mentioned. And here you have a fairly common setup for a benefit plan where you have a wrap plan, which is up at the top for the company. It's their overarching welfare benefit plans. And underneath that plan, you have a number of component benefit programs which are incorporated in. But that wrap plan document does not contain any terms whatsoever that lay out what the benefits under those programs will be. For the health plan, there's not a reference anywhere to what types of coverages there will be, how the coverages will work, how someone files a claim, how somebody seeks pre-authorization for a medical procedure. If that wrap plan document was the governing document and the only one that could be enforced, there would be no medical benefits whatsoever for wage lock plan beneficiaries. They would be left in the street with no medical coverage whatsoever. Instead, what you have to rely on to receive the medical coverage is the summary plan description. And the summary plan description is expressly incorporated as a term of the plan. In its very first line, the RAP plan says, this document and any document specifically incorporated by reference herein shall constitute the entire Swagelok Company Welfare Benefit Plan. So it says, look for other documents we incorporate. They're part of this plan. Then when it gets down to a definition of governing documents, it makes it clear those are the governing documents. It says those are the documents that contain the substantive provisions governing benefits. That's exactly what the summary plan description is. It's the document that contains the substantive provisions for benefits. And it says those are listed in attached appendices. If you go to Appendix A of the plan, you find there a listing for the medical benefit program. And you find a listing for a contract number. And that contract number is the express contract number, which is listed on the very front of the summary plan description for the plan. And so there's a clear reference and incorporation by reference to that summary plan description. It's listed in the appendices, and that appendix says, for a full description of the benefits, read the governing documents. And there's also been some discussion in this case of a term in the RAP plan, which is about benefit contracts. And if you look at the benefit contract definition, which is in the plan on page 3, it says benefit contract means any policy of insurance, trust agreement, separate plan document, schedule of benefits, or other instrument describing benefits provided under this plan. That's exactly what the summary plan description is. It's an other instrument describing benefits provided under this plan. And elsewhere, the RAP plan says, any such contract or contracts shall be named in the attached appendices of the plan. We've already talked about the fact that that summary plan description is expressly set forth in the appendices of the plan as an incorporated document. And it says further, and shall in their entirety be considered part of this plan and incorporated herein by reference. And when you look at those terms of the RAP plan document, you see very clearly that the summary plan description is not a separate document. It's in a document which is elevated by the express terms of the RAP plan to be part of that RAP plan itself. And because it is part of that RAP plan itself, the terms in the summary plan description are enforceable as express terms of that plan. And that includes the subrogation and reimbursement terms that are a part of this case. And also the plan expressly gives discretion to the plan administrator, who's named as the company, to say what happens in the event of a conflict. And it says and provides specific guidance that in the event of a conflict, the plan administrator is unable to resolve any conflict between the provisions of this plan and the governing documents. The provisions of the governing documents will prevail. It says that plan administrator is supposed to defer to the governing documents. And that plan representative was noticed for a deposition in this case, and she testified no less than 6 times that the summary plan description is part of the RAP plan and incorporated into its terms. So the person with authority has said that that is part of the plan terms, and that's what the plan says. Her interpretation of that governs. I'll reserve the rest of my time.
Perfect timing. Counselor the appellee. You will need to unmute your microphone. There you go.
Thank you, Your Honors. May it please the court, Benjamin Phelps for the appellees, Laura Patterson and Eric Patterson. in the 75 case, and then the appellants in the 78 case. May it please the court, there's a lot to unravel in this case, as I'm sure you're aware from all the pleadings that were filed. I probably won't be able to get to all the issues in this case, in these cases, given the time. I'll try and address what was stated just a little bit ago and go from there. There's a lot of issues, a lot of sub-issues. So I'll just hit the highlights. But to go into the jurisdiction issue, so what this was is this was a declaratory judgment claim against the SWAGELAC plan to determine what subrogation or reimbursement contractual rights the SWAGELAC plan had pursuant to their contract. So that's a claim that is typically brought in tort cases in Ohio and has been brought, since as early as the 40s, when contractual reimbursement and subrogation became popular with private health insurance companies. So it's a very common thing that's done in cases like this, whether it's motor vehicle accident injury cases or a medical malpractice case or any tort case.
Counsel, you're not disputing this is an ERISA case.
Well, we are disputing this was not
That is
a
an
claim.
ERISA, that is ERISA insurance, a policy.
Correct, Your Honor. It's a policy that is subject to ERISA, being governed by ERISA, amongst other laws as well. So yes, this was a declaratory judgment claim under Ohio's declaratory judgment statute. It was not an ERISA claim. It was not a claim brought under a statute under ERISA, which is typically in the context of, a procedure, a medical procedure is denied coverage. The insurance company denies coverage for that procedure. You then would file a claim under ERISA in federal courts to have that approved. That's the most common context where an ERISA claim is brought. That wasn't the case here. This was this ERISA plan, or the insurer was claiming that they had this right that was in dispute by the insured, and this was a claim to ask the court to interpret the contract to determine what those rights are, and if those rights exist, the extent of those rights. So throughout this case, the defense, the SWAGELAC plan, tried to change that claim from what it was into a claim that sought to block them from enforcing their contractual rights. Put another way, those rights existed and we're trying to override that contract, which wasn't the case here. That's not the claim that we were bringing. It was simply asking the court to interpret the contract and then decide what subrogation or reimbursement rights, whether they exist, and if they do, the extent of those rights. So that's all that was. So the court held that in its opinion and its order and said that this is a common declaratory judgment claim against the SWAGELAC plan. The court went on.
And I'm a little confused. Could I just ask you, in the amended complaint, as a prayer for relief, I understand you asked for a declaratory judgment, but did you ask anything in regard, did you pray for relief in regard to preventing or barring the collection of the subrogation?
No, at the end, Your Honor,
Right, so I'm talking about your prayer for relief. Mm-hmm.
The prayer for relief, the last sentence, it says, if it's declared that there is no subrogation rights, that they be barred from trying to enforce it. That line actually goes without saying. Again, it could have been left out. The point was that, the court declare what the rights are if they exist, and if they don't exist, that they be told that and not permitted to, continue to try and assert those rights. It could have been left out, and it was something that went without saying. Admittedly, it should have been left out because it again goes without saying. But the main point, the crux is, it was a declaratory judgment, and the court noted that in its opinion, and it said that this wasn't a claim to try and override any contractual rights. The court went on further, even though it didn't have to, and it said that even if this were to be considered an ERISA claim, it could be either a claim under 1132A3 or 1132A1B. 1132A1B provides that state courts and federal courts can have concurrent jurisdiction, meaning you could file a claim under that statute, that subsection of the statute, in in federal court or state court. So the court went on and said that, if this were, even if this were to be an ERISA claim under an ERISA statute, which it wasn't, but if it were to be, it could just as easily be considered an A1B claim, which again would give the state court jurisdiction as well. The state court didn't have to go on it and explain that, but it did anyways. So with regards to the substance of the interpretation of the contract, so what this basically comes down to is United is a large insurance company. They administer employer plans throughout the country, thousands of plans, and they have procedures in place, when they do that, when they're that large, and inevitably there's going to be mistakes made, and that was the situation here. The Swage-like plan was established, and when that happens, as is typically the case, they create the plan document, which is the bedrock contract. Okay, that's the document that governs the plan, that sets forth. Usually it refers to another document, that being the contract that's entered into between the employer, the plan administrator, the plan sponsor, and whatever health insurance company they contract with to administer the plan, that being United Health here. That was asked for in this case, and it wasn't produced. It was objected to, so we weren't able to get that. But typically, that document, that contract, refers to the benefit schedule that United has in place at the time, and that consists of all the rates for medical care. Okay, so when United contracts with a hospital or a doctor within their network, they contract those rates. So, a doctor's appointment is $100. United says, okay, we'll pay you $40 to satisfy that bill in exchange for, you're gonna have more patients now because you're in our network. So that's gonna incentivize more of our insurers to go to you, as well as the promise of prompt payment. So when an employer contracts with a large insurance company like United or Anthem, they already have these schedules in place. And the representative that testified for Swage-like in this case, she acknowledged that United already had that. She referred to it as a grid, but usually it's referred to as like a schedule of benefits or a table of benefits, and that's already in place. So United doesn't run around after they're hired by one employer. Again, there's thousands that they administer. They don't run around after they're hired to each provider with a summary plan document, an SPD, and then as they contract with these providers, the rates, then just write it down in this SPD. It wouldn't be feasible, and that's not the case. So what happened here is plan document is already in place. United's hired. They already have their rates, their price schedule in place. That's signed off on or incorporated in the benefits contract that's entered into between United and Swage-like. United, as part of their procedure, already has a SPD template to provide to the employees of the plans that they administer. And part of that template is the SPD template incorporates reimbursement subrogation terms. And a lot of times plan documents already have those terms. This is a situation where it wasn't in the plan document. So United assumed or didn't check, more likely, before they used their template, that the plan document permitted that. And after this suit was brought, Swage-like performed a post hoc type review of the plan document, and then tried to see if they could find terms that would somehow allow the SPD be incorporated. But if you look at the terms of the documents, it's pretty clear that there's no incorporation of the SPD. In fact, both documents state the opposite pretty clearly. Both documents say if there's any difference between the plan document or any summary plan document, the plan document controls. So if you take Swagelok's interpretation, you'd have to ignore those terms. You'd have to ignore how these plans are typically structured, you know, and it wouldn't make sense. So, and without this,
Counsel,
yes,
the plan document itself, though, doesn't say anything about subrogation, period.
correct,
Is that
Your Honor.
right?
Yes, Your Honor.
Okay, so how would that conflict with, or conflict, I should say, with the SPD?
Well, it wouldn't provide for the subrogation reimbursement rights. So, you know, it doesn't give the insurers of the Swagelok plan a chance to either accept or deny giving up those rights to Swagelok or United Health here. So when they go to sign up, you know, it's known that the plan document is the bedrock document. So that's where you go to look for the rights. And it comes down to basic contract law where they're not given a heads up on what they're agreeing to then. If you allow this SPD to then control, well, United makes a new SPD every year or every so often, so they can then put in post hoc whatever they want. You know, that could cause all kinds of problems. So.
Thank you.
Yeah, so the plan document refers to the benefits contract, and it also provides that it incorporates the governing, the document that provides the governing medical care. And again, that's the benefits contract, which is the contract between United and Swagelok, which either contains within that contract or incorporates the price schedule that United already had in place. So there still would be benefits available, you know, if this SPD didn't exist. Again, those benefits were already there and already contracted for by United. And that's why employers, that's the benefit they get when they hire these large insurers. They already have these contracts with the providers in place. So they know what they're going to get and what kind of coverage there's going to be. So with that, I will defer to the pleadings. I'm sorry, the other issue with being the sanctions. Going to that issue. So it's pretty clear, even if you go with Swagelok's argument and you agree with that, even Swagelok acknowledges that the plan document here is at least relevant. Without the plan document, you know, the SPD couldn't control or wouldn't be enforceable, because the plan document has to incorporate the SPD, the summary plan. So even Swagelok acknowledges that you know, the plan document is relevant and even necessary, you know, for their argument to be successful. So there's no question that the plan document in this case was very relevant and necessary for both sides, both arguments. So when we requested the plan document specifically by name, and then, you know, numerous times by description, and then you'll see in the pleadings the reference to the other pleadings where response to discovery, their answer, correspondence, where it's not just stated that they don't know if it exists, it's specifically stated that there is no plan document. And of course, you know, that turned out to not be true. And it wasn't until the pending deposition of Swagelok's representative, that document was produced, knowing that there'd be a under oath deposition, and that document, the existence of that document, would be asked about. So it's concerning that the trial court allowed the defense that, well, we referred to it as a wrap document, or, you know, you can call it whatever you want, XYZ, well, that sets some precedent where, you know, a defendant, anytime they don't want to produce something that they think isn't helpful to their position, can just not produce it, and then if caught, say, oh, well, you know, yes, it says it's this, but we refer to it as something else, and let that be an excuse. So there's some due diligence that needs to be done.
And counsel, I've let you go a little bit over your time at this point already, couple seconds. So if you'd like to just sum up for a minute or
Yeah,
less.
apologies, Your Honor. I will refer to the pleadings from here. Thank you.
Thank you. Mr. Stockert, you need to unmute yourself, and you have your 2 minutes of rebuttal remaining. There you go.
Okay. There was some discussion of this being a declaratory judgment case. You can't have you can't look at a declaratory judgment case and say, oh, this is just declaratory judgment, without understanding and looking at what you're actually trying to declare something about. And what you're trying to declare something about here is clearly an ERISA plan. That's exactly what this is. And federal court case law has made it clear that, look, ERISA is the exclusive source for rights under ERISA for ERISA government plans. And we cannot have state law alternate enforcement mechanisms for ERISA plans. ERISA sets for the exclusive ways we're going to deal with that. And under the theory that by just calling this a declaratory judgment action, it's not really an ERISA case, that would mean that there would be the open-ended alternate enforcement mechanism of any plan participant just terming their cause of action one for declaratory judgment under the law and moving forward. And that's not permissible. Also, there was some discussion here about no difference between the summary plan description and the plan. That's exactly right. The plan doesn't have anything in it that conflicts with the subrogation and reimbursement terms in the summary plan description. In fact, it has express language which incorporates those terms as part of the plan itself. There's no conflict there. And to suggest the general conflict language that says, in the event of a conflict, we're going to defer to the plan, you know, somehow overrules that. That would be completely reading out of the plan, ignoring and giving no credence whatsoever to the express incorporation terms here. On the sanctions motion, I will just say that it is very clear there's express terms here that make that summary plan description part of the plan. And it is the only relevant plan document that concerns subrogation and reimbursement rights, which is the only issue here. And there's a very well-reasoned decision from the magistrate judge that cannot be overturned absent an abuse of discretion, which is clearly not present here, that recognizes that case law supports that in an incorporation by reference context, that SPD is in fact the governing plan document for the rights we needed to deal with in this case. And that position the plan took is not sanctionable.
Thank you, counsel. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Our next oral argument via video is scheduled for Tuesday, June 1st. We are adjourned. Thank you.